Hello and welcome to Connected with Latham, where we discuss ideas, legal developments and business trends shaping the global economy. I'm Gail Crawford, a privacy and cyber lawyer here in Latham & Watkins' London office. In this episode, we're going to discuss the EU Data Act, which comes into force on the 12th of September. The EU Data Act, while wide-ranging in its focus, seeks to promote competition and innovation in the technology and data markets. And today we're going to focus in particular on the data sharing provisions. I'm joined by my colleague from the Frankfurt office, Tim Wybitul, to talk about what this means for companies that produce or use connected devices, what it means for sharing data that those devices collect or store, and what that might mean for their data privacy and cybersecurity compliance. Tim, welcome to the podcast.
Hi, Gail.
Hi. So, first question, pretty basic. Can you provide an explanation of what the EU Data Act is and what it means for the connected device market specifically?
Thanks, Gail. Sure. In a nutshell, the Data Act is the new framework on fair access to and use of data. It is part of the so-called digital strategy of the EU and applies from 12 September 2025. The Data Act is a new general framework on data ownership, data use and data sharing, among other things. And it's designed to break open what the EU calls data silos that have historically rather sat with device manufacturers, service providers, and large cloud providers. So particularly for the connected device market, and we'll get to what that means a little later, the Data Act is quite transformative. Obviously, you got to think of smart cars, wearables, industrial machinery, home automation systems, and the like. But actually, the scope of the Data Act has been quite expanded in the lawmaking process. So it now also covers, or the definition, which is pretty vague to be honest, also covers smartphones, tablets, and arguably also computers and related services. So I would not be surprised if plaintiffs and or regulators may at some point of time even argue that websites, depending on their use case, may fall under these related services under the Data Act.
And Tim, this is all data, right? We're moving away from personal data and looking at a whole pile of data that may not be personal at all.
That's absolutely right. And Gail, this is probably one of the systematic challenges of the Data Act, that it pretty much tries to differentiate or build silos that consist of personal data and non-personal data. It covers both. And in practice, it is going to be interesting to see how companies are going to try to divide the two.
So what are the key areas that it's trying to legislate for in terms of data sharing and connected devices?
There are some of them, and as you pretty much mentioned, it's not only about data sharing, it's also about a couple of other things. So it's a wide range, but today we are going to concentrate on the data sharing. So we will have mandatory data sharing for connected products and related service data generated by connected devices and related services, which must be directly accessible to the user, and at the user's request even be supplied to a third-party service provider. Then you have design obligations. That's one of the few exceptions that come into effect as of 12th September 2026. By then, new devices placed on the EU market must all be engineered in a manner so that users can easily retrieve those data by default, for instance. So that is pretty similar to or modeled after the EU GDPR's privacy by design and by default mechanism. It is data sharing by default. Manufacturers will, for instance, need to embed secure APIs or other technical interfaces already at the design stage. We will have so-called friend compensation, FRAND, where data are shared B2B. The respective pricing must be fair, reasonable, and non-discriminatory. A concept already familiar in other areas, for instance, telecoms world, but now transplanted into the IoT data world, or even the much wider playing field. And last but not least, we have carve-outs for SMEs. So micro and small enterprises, device manufacturers, service providers may be exempt from many of the data sharing duties. The aim is that innovation at the startup level may not be stifled. So overall, the Data Act aims to create secondary markets for device-generated data. It aims to spur aftermarket and repair services and reduce vendor lock-in for both consumers and industrial users. So in a nutshell, the user of the device or the service will at the end of the day become something like a data owner in many respects.
I'd also heard that one of the driving forces was to ensure that there was data sharing so that AI development could continue. I'd heard stories in the past where organizations, weren't prepared to share their data, and some of this frees this up because it's not just the consumer, right? It's business customers as well that have some of these rights.
Yes. So at the end of the day, it's an overarching data regime. And as you say, it not only covers personal data as the GDPR does, but also non-personal data, device data, aggregated data, anonymous data. And yes, that includes rules for transfer of device and services data between businesses in a B2B context.
Yeah, I'd heard a story many years ago that there was an issue, I think in Germany, where I forget whether either network providers or car manufacturers weren't prepared to share performance data, I think on the Nuremberg Ring. And it ended up going to court because they were like, this is hindering our development of autonomous vehicles. And I guess this sort of legislation could help in situations like.
Yet some of that is actually modeled after specific car manufacturing rules. So some of that is product related, and particularly the aftermarket aspects of it are pretty similar. You're absolutely right about that.
So let's not go down a rabbit hole of my recollections of fights over data from the Nuremberg Ring. So, Tim, you talked a lot about personal data being part of this. Obviously, it's a small part of this because this is much wider. But what are the challenges then between the obligations in the Data Act and the GDPR? Do they overlap in any way? And are there any potential issues that businesses need to be aware of?
That's a very good question, Gail. The lawmaker was pretty explicit in that the GDPR prevails and remains lex specialis wherever personal data are involved. And if you look at it and try to determine how to translate that into practice, the two regimes collide in at least three hotspots. First of all, you need a lawful basis for disclosure under the EU GDPR. The Data Act gives users a right to receive or access data, but the actual transfer of personal data still needs a GDPR legal basis. That can be often consent or due to restrictions imposed more or less by the European Court of Justice, CJEU, to some degree also contract. But the problems start where, and that's real life normal world, where a data set is mixed and contains personal and non-personal data, and it's not exactly easy to differentiate the two. So in that situation, controllers must try to segregate, anonymize, or otherwise divide personal from non-personal data and try to find ways how to comply with both GDPR and Data Act obligations similarly. So in my view, this entire concept either does not work in practice or will at least be extremely challenging to enterprises. And we already see that in implementation projects with our clients. So even if you actually could just technically separate personal from non-personal data, which may in most cases and use cases not be realistically doable, the criteria for the differentiation between personal and anonymous data are extremely vague. And as those of us delving deep into EU law and EU case law know, we are probably going to hear more on that on 3rd of September when a pretty landmark case is going to be decided by the European Court of Justice that pivots at exactly that differentiation. So all of this is very likely to result in civil litigation and also regulatory litigation, and as we believe, probably also fine procedures, both under the Data Act and very likely also under the GDPR. Another central issue is transparency documentation. Everyone having to do with EU data privacy law knows how burdensome the transparency notices, the information duties towards data subjects under the GDPR can be. And under the Data Act, there comes an extra layer. Manufacturers and providers of related services and connected devices basically face a dual set of notices they have to provide. So Data Act information at the point of sale, at the app, or at the website level covers device data characteristics, sharing modalities, and much more. So the Data Act brings new and also quite challenging information obligations. And this obviously needs to be aligned to some degree with Article 13, 14 GDPR privacy notices. In that context, for instance, the Hamburg Data Protection Authority recommends merging the two into one layered notice to avoid notice fatigue and contradictions between the two of them. Last but not least, we also have dark patterns prohibitions under the Data Act. It bans manipulative design that impedes a user's free choice when granting or receiving data access. And obviously, this may interact with, but is to some degree stricter, the GDPR consent rules. And it will be highly interesting how this plays out in practice. By saying in practice, very much mean in trial, because that is one of the likely scenarios we're going to see. So in a nutshell, the challenges are also reconciling real-time data sharing with GDPR minimization, data minimization, and purpose limitation requirements. It will very probably be feasible, if not necessary, to adapt GDPR. Transparency notices. Another issue will be honoring trade secret protections while at the same time providing meaningful data access. And obviously, mapping complex controller processor change when multiple parties, manufacturer, cloud host, data owner, aftermarket service, touch the same data in parallel, which is going to be interesting also with regard to potential joint controllership under the GDPR.
Interesting. So it sounds like there's a lot of areas that are going to be challenging. I particularly took away the difference in the way that the regime treats personal data and non-personal data. That obviously only works if we know which data falls into which category. And as you said, that's currently undecided pending the decision of the court. So you can see people fighting along lines there, I guess, if they don't want to disclose and what have you. I think that the trade secret protection is an interesting piece as well, because that presumably could be used by people who hold data and should be sharing it to try and hold on to it and not sharing it. I'm not saying it'll be used perhaps badly, but you can see how it could be used tactically. Any thoughts on that?
That's something we have analyzed pretty closely because, as you suggest, Gail, it's one of the questions we are being asked by our clients. Yes, it is quite a challenge to remove trade secrets from the data to be shared. That also is going to be a practical hurdle that's not easy to take. But it's also the Data Act provides a mechanism that whenever you do that and whenever you basically do not comply with data access requests or carve out trade secrets, you're under the obligation to notify the relevant authorities. And that, again, is a well-known concept under other EU digital acts and often creates some extra work and exposure.
Makes sense. So you effectively are obliged to tell them why you are not sharing and justify your position.
Sums it up pretty well.
So on that basis, what do we think enforcement's going to look like? Where do we think the regulators are going to focus? And if I understand it correctly, this is a law that will be enacted through local legislation ultimately. So the fines could differ from country to country. Is that right?
Yes, to some degree they could, but that's only some degree. So, as you say, the enforcement is going to happen mainly on a national level. Not surprisingly, not all EU member states have implemented or assigned and determined the respective regulators on a national level. So, for instance, as we know, the Data Act is going to apply from 12th September 2025. In Germany, we don't even have a competent authority, much less even a draft act to implement the Data Act and the authority structures on a national level. So it's not likely at all that we're going to see something happening until 12th September. That would require funding, that would require hiring and all of those things. So we are likely to see national authorities emerging at a later stage. And that's why there are many reasons to believe that the data protection authorities will take the lead on this wherever personal data are in play. First of all, the Data Act itself stipulates so very clearly. So the data protection authorities are competent for anything having to do with personal data in a Data Act context. And then we're going to see the other Data Act authorities acting in this context more or less for non-personal data. And many new data protection authorities have already made clear that this is a field they embrace or an area they embrace. So, for instance, the Hamburg Data Protection Authority has already made very clear that it will treat Data Act complaints as data complaints under the GDPR, under Article 77, and will use not only its investigative powers and fine powers, but also their tool set of mechanisms they have developed and processes. So data protection authorities have already made very clear that they may also issue GDPR fines for violations of other EU digital acts, including the Data Act. In that context, the protection authorities argue that any processing of personal data requires a legitimate purpose under the GDPR, and a purpose cannot be legitimate where it violates the Data Act, the AI Act, the DMA, the DSA, or other EU laws. And obviously, they are of the view that such processing activities cannot rely on legitimate interest as a legal basis under Article F GDPR either. And that's pretty much in line with a CJEU decision we saw a couple of years ago in a Bundeskartellamt context. That's why the data protection authorities will play a very strong role. Then, aside from that, competent authorities will have to be designated by most member states, and they will police the non-personal data, FRA&D pricing disputes, cloud switching duties, and quite some other things. You hear that the German government, for instance, is leaning towards the Federal Network Agency, the Bundesnetzagentur, which is also likely to regulate the EU AI Act for these functions. But that's candidly not quite clear yet. On liability, as you say, administrative fines, Gail, are likely to mirror GDPR levels. And as with the GDPR, these fines must be effective, proportionate, and dissuasive. So regulators may consider issuing even cumulative fines where the same incident violates both the Data Act and the GDPR. And given the fact that the fines must be effective and dissuasive, it's not likely at all that low fines are going to pass that bar. Other than that, we're also going to see civil redress, which, as the example of the GDPR shows, can not only result in considerable mass litigation, but also the same will be true for the Data Act. And the Data Act also adds claims under it to the EU collective redress regime. We expect representative actions by plaintiff law firms, consumer organizations, SME associations, and the likes appearing on the horizon. So for them, it's a field to earn money, and that makes it very likely that we are going to see quite some activity there. And as you know, we already have such a mass claims phenomenon under other EU digital acts, particularly the GDPR, in quite some member states, including Germany, Netherlands, and others. And we expect that not only to be reloaded, but pretty much intensified with the Data Act, because it's pretty easy for claimants to use the same arguments the data protection authorities have already used, and to say that this also gives rise to claims for material or immaterial damages under Article 82 GDPR. So we expect plaintiffs plus law firms to argue very similarly. And it's likely that it will make it even easier for them to claim immaterial damages under the GDPR plus the Data Act this way. The good news in this context is that the individual claims granted by courts, if they are granted, normally are low. Some €100 is pretty much where something around €100, for instance, is a pretty standard figure in German courts. But the leverage behind that still can cause problems. So another issue where we're going to see quite some activity is contractual exposure, because there's a high likelihood that contract parties may argue that trying to circumvent, trying to avoid, trying to waive Data Act rules is first of all, that these clauses can be null and void. And obviously, that could also give reason to termination, depending on how one argues. So we expect early enforcement by the DPAs, by the data protection authorities. We expect plaintiff firms to closely analyze what they can do with that, and probably starting with that early. And we expect consumer organizations to test the waters and see how this can be used to do something against big tech, candidly.
Yeah, all makes sense. So on the back of all of that, what are your key takeaway from businesses? What should they be doing right now?
That's a fair question, Gail. The observation is that a lot of firms are realizing just now that they may have underestimated the Data Act to some degree. And that's why they do not have much time to change processes and structures. So we have some early adopters, and we have learned some lesson from working with them. At the end of the day, it is an exercise where you clearly should start with potential litigation in mind. So the areas you should concentrate on are those areas where customers, plaintiff firms, consumer organizations, competitors even, may benefit from suing you or reporting you to Data Act watchdogs, including the data protection authorities. And one of the patterns that help you defend against that is really to get into a defensible litigation strategy. For instance, where you have information obligations, it's pretty hard to put up a good defense if you don't inform your customers. However, if you have something in place, even if it's not ideal, that gives the trial lawyers a much better chance to prevail in court if necessary. So, four immediate actions items come to my mind with which many companies start. First, obviously, is the scope and gap analysis. So, inventory of the connected products, the data processing services one is offering, confirming and determining what role you're in. Is it a manufacturer? Is it a data holder? Is it a user? More interesting for plaintiffs, obviously. Cloud provider, or a combination thereof, depending on the different use cases. Then, obviously, looking at it from a technical feasibility enablement perspective. So, what needs to be changed? Functionalities need to be implemented. What processes need to be implemented? Information processes, secure interfaces, control, like, for instance, making sure that trade secrets that are not going away, that interfaces are not misused. Real-time access in that context may require quite some technical solutions. Obviously, contract work, remediating contracts, updating customers' terms and conditions, aftermarket service agreements, cloud MSA. There are a lot of obligations and a lot of things that only work under the Data Act if you have a contract in place. And so that's certainly one of the key areas. And then also things like integrated notices, consent flows where consent is a legal basis, align Data Act disclosure obligations with GDPR privacy notices, potentially e-privacy requirements, avoid dark patterns, and see where you need consent and where you have it in place.
Makes sense. A lot to think about. And I guess longer term, sort of ensuring the right governance is in place to make sure as sort of products come online and get developed that you're building them with data sharing in mind. I guess we've had privacy by design. It's now sharing by design.
I think that's a fair summary, Gail. We will need data governance operating models. There's going to be a lot of compliance around the Data Act, so it's work in different departments of firms. So good start for those who have done little is creating a cross-functional Data Act steering committee, looking at the legal, privacy, security, product, commercial terms, contractual terms. Then obviously safeguarding security and trade secrets and implementing the technical measures you need to protect confidential algorithms, telemetry, while still sharing user data in the degree required by the Data Act. For cloud providers, it's going to be a huge lift, building a multi-vendor architecture, enabling cloud switching, standardizing exit formats, running drills on the new switching timetable. So that will be an issue for this area of business. And then again, monitoring, policy engagement. It may make a lot of sense to influence new member state governments to come up with implementation laws that are realistic, doable, proportionate, and also developing or working towards technical standards, towards best practices that can be used realistically and as a defense in litigation too.
Makes sense. It's super interesting. I mean, it really does seem to redistribute, I guess, the bargaining power within the value chain and ensure that those that hold the data can't use it only to their own advantage. I guess that was the intention, but whether it plays out that way will remain to be seen. Any other final thoughts from your side?
Yes, Gail, to answer your last thought, I don't think that the goal of making the user king is going to be achieved. I think that some firms are going to make huge money out of the Data Act, probably not users, but those firms gathering and collecting users, pretty much like with immaterial GDPR damages claims. And I think the Data Act is a game changer. It's not just another new digital regulation. Basically rewires digital value chains. It governs data ownership, redistributes bargaining power, and will result in massive changes. I think business that treat it as a pure compliance exercise will miss strategic upsides, such as creating new offerings, partnering with other firms, seeing where you can make use of the Data Act and of the data sharing obligations. So, starting planning, strategizing, designing, I think the firms that are going to do best within this change market are those that look at the Data Act not only from a compliance and burden perspective, but also from an opportunity and strategy perspective.
Makes a lot of sense. You can use it offensively and defensively, I guess. Well, thank you, Tim, so much for those insights and background. It's extremely helpful. And thanks to our listeners for joining us on this episode of Connected with Latham. There's certainly lots to be thinking about with the Act coming into force on the 12th of September. If you'd like more information about the topics in the podcast, please do get in touch with us. Both I and Tim are happy to talk to you about specifics in detail. We hope you will join us next time.
Thank you, Gail. It was great speaking with you.
Thanks to you all for listening to this episode in our Connected with Latham podcast series. You can subscribe and listen to new and archived episodes of the Latham podcast on lw.com, Apple Podcasts, Spotify, or wherever you get your podcasts.
This podcast is provided as a service of Latham & Watkins LLP. Listening to this podcast does not create an attorney-client relationship between you and Latham & Watkins LLP, and you should not send confidential information to Latham & Watkins LLP. While we make every effort to assure that the content of this podcast is accurate, comprehensive, and current, we do not warrant or guarantee any of those things. And you may not rely on this podcast as a substitute for legal research and/or consulting a qualified attorney. Listening to this podcast is not a substitute for engaging a lawyer to advise you on your individual needs. Should you require legal advice on the issues covered in this podcast, please consult a qualified attorney. Under New York's Code of Professional Responsibility, portions of this communication contain attorney advertising. Prior results do not guarantee a similar outcome. Results depend upon a variety of factors unique to each representation. Please direct all inquiries regarding the conduct of Latham & Watkins attorneys under the New York's disciplinary rules to Latham & Watkins, LLP, 1271 Avenue of the Americas, New York, New York, 10020. Phone number 1-212-906-1200.